Now, it is admittedly rare that I agree with Justice Jackson. However, in this dissent, she makes a pretty good point. Monsanto argues that 7 U.S.C. sections 136 VB, a provision of the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA, expressly preempts Durnell's failure to warn claim, providing the state labeling requirements that are, in addition to or different from those required under FIFRA, are preempted. Today, the court agrees. The majority emphasizes that the Environmental Protection Agency has consistently registered Roundup, a precondition of Monsanto's ability to sell the product, and thus approved Roundup's label without a cancer warning. According to the majority, the EPA's registration decision and approval of Roundup's label created a labeling requirement under FIFRA, namely that Monsanto sell Roundup with the label exactly as the EPA approved it. Thus, the majority concludes Durnell's lawsuit added a labeling requirement that federal law did not require, triggering preemption under 136 VB. Justice Jackson brings up the idea of the EPA label preempting state law because of 136 VB of FIFRA. As Justice Thomas pointed out in his concurrence, this does not square with either the separation of powers or the supremacy clauses of the Constitution. But Justice Jackson points out another constitutional violation, even if she doesn't specifically name it in her dissent. In so holding, the court departs from the near unanimous view of many state and federal courts that have rejected this preemption argument. In my view, the majority should have joined that chorus. Durnell's failure to warn claim is not in addition to or different from FIFRA's mandate. It is equivalent to FIFRA's key labeling requirement, the misbranding prohibition. And Durnell's claim does not conflict with any other FIFRA requirement for the 136 VB purposes because the EPA's registration of a pesticide and approval of its label does not create a labeling requirement under FIFRA. Now, Justice Jackson focused on whether or not a state's law conflicts with, rather than augments, FIFRA's labeling requirements. The point she misses is that by prohibiting Mr. Durnell's lawsuit, the court violates the petition clause of the First Amendment, which reads, Congress shall make no law abridging the right of the people to petition the government for a redress of grievance.